Hey everybody, welcome to Thursday night. John Skiba here from the Consumer Warrior YouTube channel and coming to you on a Thursday night, I guess what I could call a holiday edition of the Consumer Warrior live stream that we do each and every Thursday night. It's a Thursday after Christmas. I hope you all had a very Merry Christmas. Hope you're having a good holiday season. I'm spending some time away from the office with family up in Pine Top, Arizona. My law practice, I'm a practicing attorney down in Mesa, Arizona, in Phoenix area. I have family, my wife's family actually lives up in Pine Top. And a lot of people are unaware that in Arizona, we have what you're seeing in my background here, pine trees. Pine Top is at about 7,500 feet elevation, thick pine trees, beautiful place. So you're getting the casual, unshaven, me hiding out in the bedroom at my in-laws' house doing the live stream today. But my name is John Skiba. I am a consumer attorney in the state of Arizona. I do bankruptcy work. I represent people who are getting sued by debt collectors. And what we like to do each week on the live stream is for you to put questions and really kind of dive into some of these topics. So whether you're on YouTube or Facebook, and I think even on Twitter now, if you're watching this on Twitter, you can put your question in the comment section, in the chat section, and we'll put it up here. We'll put it up on the screen, and we'll talk about it. My disclaimer, which I'm sure everybody's tired of, which I give each and every week, is that while I'm a practicing attorney in Arizona, I'm not licensed anywhere else. So this should not be considered legal advice. This is a guy in a hoodie at his in-laws' house talking about the law on YouTube. So if you need an attorney, find someone in your particular state. Or you can contact my information below if you're in Arizona, or you can reach out to me and I can help refer you to someone who could be able to help. Now, I had a few comments from the channel that I wanted to go over. The first one has to deal with a topic we talk about pretty frequently related to debt collection lawsuits, is filing a motion to compel arbitration. Now, this is based upon an arbitration clause that's contained within the credit card agreements of most credit cards. This person said, what does it mean claims are not subject to arbitration if they're filed in a small claims court in your state's equivalent court, so long as the matter remains in such court, MISOL, which I think stands for sorry out of luck. So the arbitration clause, this is a common phraseology, terminology, kind of the legalese of an arbitration clause. And what they're saying is if either you or they initiate the case in a small claims division, small claims typically deals with very limited amounts, and usually attorneys are not permitted. Like in Arizona, the small claims division of the justice court system, it's anything under $3,500, but attorneys are not allowed to practice there. So that's why you see typically, because most lawsuits are filed by junk debt buyers or by credit card companies, and they're going to have attorneys. So unless it's in your small claims court, typically you can ignore that. Like in Arizona, if they file it in the justice court, that's not small claims court, even though there is a small claims component of it, so we can get it tossed out. So this person had a question about Chapter 7 bankruptcy. Said, will they try to take my house if I file Chapter 7? I'm retired and my Social Security has been stopped for 5 months now. So it's important to know, one thing I talk to all the time about people when I talk to them about bankruptcy is whether it's Chapter 7 bankruptcy or Chapter 13 bankruptcy, all debts are not created equal. And if the debt is secured by collateral, if there's property attached to it, car loans, home loans, if you want to keep the car, if you want to keep the home, you have to continue to make the payment on it. So they're not going to try to, in a chapter, just filing Chapter 7 doesn't mean you're going to lose your home. But one, you're going to have to continue to make your payment on it. Two, if your house is paid for, it's going to have to be within the exemption limit, your homestead exemption limit. So for example, in the state of Arizona, the homestead exemption protects up to $400,000 of equity in the property. That's protected. So as long as your house is worth less than $400,000, if it was paid for, then they can't touch it. It's important to know that's equity in the property as well. So let's say that you have a home that's worth $600,000 and you still owe $300,000 on it. There's only $300,000 of equity, so you're still within it. So So just because you file bankruptcy doesn't mean you're going to lose the home. It does, but like I said, you have to continue to make the payments on it, whether it's a car or a home. There's no free house, there's no free car in bankruptcy. All right, so this one, and maybe this person's watching tonight and can comment on it. I went through the comment and I saw this one. This is a topic I get a fair amount of pushback on. This person basically said that the channel's slipping. I don't know what I'm talking about, kind of thing. And this relates to debt collection lawsuits and avoiding service. Their comment said, avoiding service is an excellent tactic, especially when it works. An unorganized law firm doesn't stay on top of things and fails to serve in time or file an alternative service. And they went on and on about why I'm an idiot and I don't know what I'm doing. Here's why I tell people. So, in just some context to this, when a debt collector files a lawsuit against you, they file the complaint, they file the summons, and then they are required to serve you with that. And once they serve you, that starts the clock ticking for you to file a response. A lot of people online, you'll see them say, "Oh, just avoid service. If you can just avoid that process server, if you see them coming, just close the blinds, don't answer the door." Especially now in the age of the Ring doorbell, I see a lot of this where people are like, "Hey, you can see." Here's why I say don't do that. Just get the complaint and summons, and let's deal with this head on, because the law has a way around that. If people are avoiding service, they can go and they can get what's called an alternative service order, and they can serve you through the mail. And most people don't see that, or they don't check their mail, and then they end up with the default judgment. So that's why I say, I talk about that there are defenses that we can use to fight against the debt collectors. Take those and use those, but don't avoid service. Just deal with it head on. If it's one of those things, if it sounds too good to be true, then it is. If it's something where if you could just not get served and avoid that forever, you're not going to end up with a judgment. It's not true. So you got to be careful there with some of those things that are out there. All right, let's see. Destin was here, nice and early. Says, under what conditions can a creditor request an adversary proceeding? So, and this is a bankruptcy question as well. So adversary proceedings in the bankruptcy realm, in the bankruptcy realm, adversary proceedings they're kind of like little mini lawsuits within the bankruptcy. So you file Chapter 7 bankruptcy, and if one of your creditors wants to have their debt be taken out of the discharge, if they want to say, hey, our debt doesn't go away, they actually have to file a lawsuit against you. And there's very limited reasons why a debt collection lawsuit or not debt collection lawsuit, as far as why a creditor, a debt, would not be included in the bankruptcy discharge. Things like fraud, things like misrepresentation, some things like automatic things like domestic support obligations, like child support, alimony, that kind of stuff. So under what conditions? They've got to have a pretty good reason, and they're very rare. It's interesting because when a case gets filed with the bankruptcy court, they assign a case number, and you can see how many cases are filed based upon what number. Like if your case number ends in 5,000, you were the 5,000th case filed that year. Arizona sees anywhere from 15 to 30,000 bankruptcy cases filed every single year. It's in maybe 1 to 300 adversary proceedings. So super rare. And truthfully, most of those are even filed more in Chapter 13s or even Chapter 11s. So it's highly unlikely. So, all right. Follow-up question. If I file a motion to compel private arbitration, how likely will a creditor not pursue the case against you? It depends on a couple factors. Depends on the law firm handling it. Depends mainly on how much is in dispute. If this is a $3,000 lawsuit or a $1,500 claim, they're probably not going to follow you in there. If it's a $60,000 American Express claim, they'll probably follow you in there. So what I have seen is the amount in dispute, the amount that they're claiming is owed, is going to be the biggest deciding factor overall, whether they follow you in there. My advice to you is always, if you are going to file a motion to compel arbitration, you have got to be prepared to move forward with that in good faith. You've got to be prepared to do that, because you can't just say, okay, I'm going to file this in hopes that they don't follow me in. They may not follow you in, and it may be a good strategy to do that. But at the same point, you've got to be ready to move forward with it. So, all right, let's see here. Oh, Candace is calling me out. I like what you're doing, but you're wrong on avoiding me server. And I don't. And I guess I was thinking about this later. The point that this guy brought up, avoiding service may work here and there. Overall, what I responded to him on the channel in the comments is, I've been doing this for over 20 years. I have represented probably around 15,000 people in debt collection lawsuits. And so that's where I start to see the volume. If we're talking just general principles, I'm going to say don't avoid service, accept it. Are there times when it works? Of course there are. But I'm saying as a general principle, I've seen way more default judgments and wage garnishments due to avoiding service than I have seen it work the other way. So, all right, Alex, my man Alex in Yuma. Alex, have you ever been to Pine Top? It's a little different setting than Yuma. Yuma's the ultimate desert. It's like the hottest place in Arizona. Alex says, what should you do when you first get contact from a junk debt buyer advising they now own your charged off account? This is a good question, and one I've come in, fairly frequently in the last month or so. It seems like with a lot of the consultations, because under the Fair Debt Collection Practices Act, when the junk debt buyer, if they become in possession of an account, the law requires them to send notice to you that they are now the owners of the account, and then they give you 30 days to request a validation of the debt. I think it's always good to send a validation letter. You'll see in the chat section, I put a link to SoloSuit. SoloSuit's one of the sponsors of the weekly live stream. They have a really slick automated system for doing a debt validation letter. Debt validation is a couple things. One, it gets you additional documentation so you know exactly who you're dealing with. If you get a letter from Portfolio Recovery or Unifund or Resurgent, LVNB, you're probably thinking, who in the world are these people? I didn't enter into any contracts with them. And so they have to provide you with the documentation that are there. So that's why I say do the validation. Two, the Fair Debt Collection Practices Act, that FDCPA law, requires when you submit a debt validation letter, they have to stop all collections until they respond to it. And so especially if you're trying to get money together to do a settlement, or just, you need some additional time, submitting that will not only get you the information, but it's going to buy you a little extra time to get things dealt with. So, all right. Jason says, just wondering, can I start applying for a new credit the moment my accounts on the credit card go from the petition for a Chapter 7 to discharge, or do I need to wait until I receive the notice in the mail? Something you're bringing up is something that a lot of people are surprised, is as soon as you file the initial petition in the Chapter 7 case, I have clients tell me within days they start getting advertisements for credit cards and car loans in the mail. So it is possible to get a credit card relatively quickly after a Chapter 7. You can get normal mortgage loans around 18 to 24 months, like FHA, VA, they do it 2 years after a Chapter 7. So you can get a credit card. I always tell people to be careful. I mean, particularly if you're filing bankruptcy over credit card type issues. I know it's hard. This is one of the areas where I definitely deviate from Dave Ramsey. I've talked about in the past, I'm certified through Dave Ramsey's organization. I used to teach Financial Peace University a lot. I like to use my little name drop thing. I've had dinner in his home, in his house with Dave Ramsey as part of this group of attorneys that would go and meet with him for his courses. The credit card, it's hard to operate in the world without a credit card. Like the car rental thing, for a while, my wife and I did that. We just used debit cards, and I got stuck in airports. I can't tell you how many times. Everything else I seem to would work fine with the debit card, but credit card for car rental, for whatever reason, the credit cards, they make it difficult. So you can start applying for them. It's just you got to be careful. And you're going to have horrible interest rates early on, particularly with the credit cards. So, all right. Joe says, have you ever dealt with the law firm Rausch Sturm? Anything to be aware of? I have dealt with them. I've dealt with them recently. I actually had a trial against them. I even think I posted a picture of outside the courtroom the day we went to trial. So what they are a law firm. They're a multi-state law firm, and they tend to find local counsel to represent them. I believe they're based out of Texas. So depending on where your case is being handled, if it's outside of Texas, they usually find a local attorney to represent them during the hearings. In that case that I had with them, they weren't prepared for trial. I don't know what happened there. They showed up. They didn't have any witnesses. The attorney didn't have a lot of information about the case that they had hired to handle it. And we ended up having the case ruled in our favor, and we're waiting right now. I think we're getting an attorney's fees award against them. So, or against their client, not the law firm. So that I don't deal with them a lot. Just they are based out of Texas, and then like I say, if they are in a different state, I believe I've had matters seen filed for them in Nevada, Arizona, Texas. I don't know if they're just to the Southwest, but that's just you're likely not going to be dealing with an attorney. You'll be dealing with what's called a contract counsel. Usually these are attorneys who they're just being hired for, Roush will reach out, hire somebody to represent them at one hearing or the trial or one specific component of it rather than the thing overall. So, all right, let's see here. Red Machine says, can I file an amended response to a debt lawsuit? Yes. So what the rules state in most jurisdictions is that there's a certain time period. I believe it's under Rule 13. I'm drawing a blank if I'm just saying that. But anyways, the same answer, whatever it is in your state. Rule 12 for filing an answer, but maybe Rule 13 is for amending the pleadings. There's a time period. So if you file your answer, you usually have like 14 days or 21 days or 30 days where you can file an amended response to it or file an amended answer to it. And then if it's outside that time frame, if you file your answer and then 5 months down the road, you want to file an amendment to your answer, it's something where you're likely going to have to get permission from the court. They call it leave of court. So if it's something where you filed your answer and then a week later, you're like, oh, I should have put this in. Look at the rules, look up amended answers, just Google that, go to Google Scholar. That's a good place to do it. Go to ChatGPT. That's a great place to do it. Because amend the answer in your particular state. It'll give you the rule. You can look and see what the time frame is. And as long as you're within that time frame, you can just go ahead and file the amended answer and submit a copy to the other side. They will have to file because there's nothing for them to respond to. That's why you're able to do it. But if it's something where it's been a couple months and you're outside that, you're going to have to file a motion for leave to amend your answer. And there's a whole process there that's going to be unique to each state. And the other side can also review it and object. But the courts will often grant that. The rules usually say that they're to liberally allow that to happen unless it's, right before the trial, that kind of thing. So, all right. Well, I think we'll do that, close that up for tonight then. I appreciate y'all checking in on this holiday week. Hopefully you've got a little bit of time off to be able to relax as you're heading into the new year. I've got a lot of good content coming your way. We're going to kind of change a few things up, but I'm excited for 2024 and some things we're going to be offering. And with that,